Okay, this is the ninth article of hundreds to come, serving others as international consultant of economic and government choices. We're talking about the epitome of a bank's personnel federally violating the bank's stockholders' investment and the owners of the bank director law firms' owners or stockholders. And under law, these bank personnel accept the felony liabilities. Now, to avoid being a federal felon accomplice or being prosecuted of the same bank's fraudulent government documentation, these articles and these public service announcements of my full disclosure to all international, U.S., and Security and Exchange Commission investors, I'm giving full disclosure. Now, the First Amendment of the Constitution guarantees me my rights of freedom of press and freedom of speech. So constitutionally, this full disclosure protects me from being prosecuted as a federal felon accomplice. Now remember, I have exhausted all courts trying to get this cleared up, and all courts have chosen their constitutional rights to create new case law changes. Now, the U.S. Federal Debt Collection Practice Act of 2010, when you use deceptive forms, and the law reads, when you use deceptive forms, any person who violates this section shall be liable to the same extent and in the same manner as the debt collector is liable. So in other words, if you're a bank personnel, you're fully accepting, as the bank is, the liability for illegal debt collection. Now, when you go to filedevidence.com, Exhibit 9's filed evidence proves beyond a shadow of a doubt the premeditated epitome of a bank's personnel felony filing and recording fraudulent government deceptive forms and their acceptance of the liability according to law. Now, on October the 30th, 2014, prior to the November 4th, 2014 meeting when the bank demanded an exit strategy, this premeditated letter was created. And on November the 7th, 2014, the bank's personnel deceptive forms for felony attempting to change the Artho Quarters deed with the correct legal description as proven in Exhibit 6 all the way back to the Republic of Texas in 1836 and all the way back to when Texas joined the Union in 1845 when the U.S. Congress approved all correct legal descriptions. We're still under these same legal descriptions all the way back to 1836. Okay, on November the 7th, 2014, 3 days after the bank's November 4th, 2014 meeting, the bank violated the bank's stockholders' investments by felony filing and recording this premeditated fraudulent government document within the bankruptcy courthouse with naming my Artho Quarter from legal description to an illegal legal description as a deceptive form against the law. Now, this prevented me from refinancing my excessive equity 3 days after the bank's demanded exit strategy. Now, as you remember, there's been many fraudulent filings and recordings of government documents and loan documentation. And I can't tell you what happened, but apparently they didn't want me having any chance of refinancing by excessive equity. Okay, this premature or premeditated epitome of bank extortion of collateral on my Artho Quarter Energy development site, which was MLS listed at 2.1 million, a half mile from a 750 megawatt substation, with a deep Santa Rosa well, which is 2 miles from the bank director's, lawyers, and sons development with shallower wells. Now the Artho Quarter can't be sold or traded or refinanced due to the federal felony filing and recording of the Artho Quarter as now being an uninsured, unmarketable property with an illegal legal description. Now later in Exhibit 21, this non-existing Artho Quarter with the illegal legal description and Apache points filed a recorded deed with an illegal legal description, and my AA property, which was filed in the wrong county. Now this creates the bank's imaginary collateral of 3 imaginary cards and was counted twice in the bankruptcy court proceedings. Now you can smell what I'm sniffing. I mistakenly and naively trusted my bank thinking they were regulated and enough not to ever let something like this happen. And when I received this letter informing me what they were going to attempt to change the Artho Quarter's legal description, I mistakenly and naively believed my paid legal counsel to research this. But my paid legal counsel failed to research. So I was personally forced to research all 5 county courthouse records on my own because I knew something was wrong. I didn't know what. Now I presented to my last paid legal counsel Exhibits 9, filed evidence, and more of what I had discovered. Yet my last paid legal counsel failed to present it to the court during the bankruptcy court proceedings. Now, after all legal counsels breached contract and abandoned me and forced myself to represent myself, to present the filed evidence to all courts of law, seeking my constitutional 14th Amendment rights of equal protection of the law to protect my investments. Now, when you go to filedevidence.com, the letters to the law reporters describes these new case law changes that in spite of filed evidence and in direct defiance of the current laws, the courts chose to exercise their constitutional rights. And these landmark decisions, they ruled in favor of the preferred absolute powerful's agenda. Again, constitutionally, we're all created equal. So now anyone can file and record any fraudulent government document and or loan document to extort collateral within any county courthouse, to ruin and slander anyone's deed, name, reputation, credit, refinancing, or future earning powers against anyone so chooses. Now anyone is judicially allowed to force government confiscation of these extorted and slandered collateral to clear up the slandered titles they themselves created and slandered by filing these fraudulent documents in any courthouse. And of course, as we've talked before, This, anyone can quote these new case law changes to any judge and any jury in any court of law from this day forth. And again, any past felons that are in prison, this should be their get out of jail free card. And any district attorney trying to prosecute present felons going to have a hard time doing it by quoting these new case law changes and future felons' unsustainable short-term ill-gotten gains. Now, later exhibits will confirm like-kind extortion and slander new case law changes when the racist, misogynist discrimination of these same type items against the civil rights of my innocent third-party wives, filed and recorded, woman of Hispanic and Indian heritage, exempt, 95th release, prenup, and separate homesteaded Lamar County, Texas ranch. Now, there were two attempts to government confiscate her property. Now, first, the Dallas County federal felon lawyers went to the 95th District Court with bankruptcy fraud and obtained a scam state judgment, which of course is illegal, and scammed it within my closed and settled prenup and separate federal bankruptcy proceedings. And this scam was done by my own lawyer who was supposedly representing me. Now, Lamar County, as a federal felon accomplice, officials, they attempted a courthouse step rad sale against my innocent wife's property to try to government confiscate it. And of course, her filings at the courthouse proved it's homesteaded exempt, and it simply can't be done. And that we'll get on that one in later exhibits. Now, the Dallas County's federal felon accomplice lawyers, real estate company, and title insurance company abused these same type of extortion and slandering of the same type filed and recorded in Exhibit 9. Now, the scam's personal liability of this notice of correction that was mailed from Canyon, Texas, where I personally knew the bank's personnel and I personally banked them. Now, the scam's personnel liability of quoting Texas correction laws, when in fact, there's no law in Texas give anybody any right to go in and change a deeds filed and recorded legal description to an illegal description. And this goes all the way back to 1845, like we talked about before. And in this scam, Amarillo, Texas trustee, I did not personally know, as required by law. And this Amarillo, Texas felon bank employee's premeditated liability knew full well that the bank had already filed and recorded my Arthur quarter with the correct legal description. And now they're trying to do it with an illegal one to keep me from refinancing. Okay, the scam's Amarillo, Texas felon employee, who I did not personally know, and that's required by law, nor did I ever sign this fraudulent government documentation. For if I had signed it, I would have been that would prove me as being a federal accomplice to bankruptcy fraud. Now, in international consulting of economic and government choices, extortion and slandering new case law changes within any nation. This divides any nation's tax-paying commoners against and stockholders and owners and international stockholders and owners. It divides you against and to never ever trust those who created, inflicted, and or allowed these new case law changes for their personal, unsustainable, short-term, ill-gotten gains. These fraudulent government documentation within any nation, well, of course, it ruins the reputation, decreases values, and eliminates future earnings of any nation's investors' sustainable long-term investments. However, any nation's investors can still demand U.S. retribution for losses owed to them from these federal felon accomplices for slandering the reputations of them, for their loss of client and client disassociation, and their future earning losses suffered by the following victimized entities and more: the bank's stockholders, owners, the law firm's stockholders and owners, real estate companies, stockholders and owners, title insurance companies, stockholders and owners, U.S. Bar Association member, Texas Bar Association members, Dallas Bar Association members, U.S. state and county investors' investments, SEC investors' investments, all international investors' investments, economic development boards whose tax-paying commoners' investments funded them, and their loss of development due to these new case law changes. And of course, any innocent third-party woman of Hispanic and Indian heritage prenup and separate investments. And of course, any banking customer such as myself. This U.S. retribution is owed to all these victims under the U.S. Constitution of the 14th Amendment rights of equal protection of law, required to protect all investors of their U.S. investments. Now, remember, U.S. federal law of racketeer, influenced, and corrupt organization act of 1970, and which is commonly referred to as RICO, requires by law, by federal law, all racketeer irrevocable damages lost by all these people and more by law is required times 3. In other words, whatever the damage was, it's times 3, and that equals the retribution that all these people and more are owed for the victims for being racketeered against. Of course, all nations consider this type of self-sabotaging economic disasters as nothing more than high treason. When any Department of Justice is hell-bent is hell-bent on destroying any nation's economy. This, in my opinion, should be considered high treason. But when you go to filedevidence.com, you look at the filed evidence, what was filed in all the courts, because in America, you can think, feel, and or believe however you want to. But the filed evidence will prove beyond a shadow of a doubt